The Eastern Caribbean Collective Organization for Music Rights, Ecco, is hopeful for an amicable resolution to the ongoing dispute with the government of St. Kitts and Nevis regarding its rights to operate in the Federation. The Ministry of Justice and Legal Affairs had issued a press release recently indicating that Ecco and any other collective management organization are not authorized to operate within the jurisdiction of St. Kitts and Nevis at this time. The announcement follows the enactment of the Copyright Collective Management Organization's CMO regulations, which came into effect on December 6, 2024. These regulations create a mandatory legal requirement for all CMOs to obtain prior authorization from the Intellectual Property Office of St. Kitts and Nevis, IPO-SKN, before issuing licenses or engaging in any collective rights management activity in the Federation. However, in a recent interview with SK Newsline, representatives of Ecco said they had needed more time to comply with the requirement of the regulation. CEO of Ecco is Martin James.
So Ecco received a letter from the IPO through the Attorney General's office. We received a letter indicating, well, rather an instruction, indicating that the new legislation was passed on the 6th, and we received that letter on the 10th, literally 4 days after it became law, indicating that if we are to adhere to all the provisions and all the requirements of the CMO regulations, and if we don't, then we could no longer operate in the territory. So we found that a bit unkind and unfair. So because we've been operating very well within the organization, within the territory. So through our attorney, we wrote to the Attorney General indicating that we wanted to invoke a transitional period.
Ecco sought an injunction last week to suspend the enforcement of the 2024 copyright CMO regulations. The court denied the injunction.
The judge thought it necessary that the two parties go and discuss to see that we are now in compliance with the registry, of the business registry, and as such, we now have all what we need to file or to present to the IPO's office for that recognition for us to do.
SK Newsline asked Ecco's agent in St. Kitts and Nevis, Grace Richardson, what happens in the interim.
As it stands, if a local promoter right now is putting on an event, or anybody for that matter, where music is going to be performed publicly, do they still need to get an Ecco license if the AG's office is saying Ecco is not authorized to perform unless they are in compliance with the legislation?
Okay, I'm going to answer that in a similar way to Mr. James, because you have to realize that a CMO is given the authority by the exclusive rights holder. The exclusive rights holder is the first rights holder, right? And if we cannot do that, then the person who is putting on the event or having the show has to, under the Copyright Act Section 7, contact the exclusive rights holder, which is the creator. That's a simple answer to that.
And if they don't, then they're infringing on the law.
And if they don't, they're committing an offense. The copyright law, the Copyright Act is clear.
In a press release from the Ministry of Justice and Legal Affairs issued after the court refused to grant Ecco's injunction, Attorney General Garth Wilkins said, quote, "The regulations are designed to ensure lawful and credible collective rights management. They protect our creative industries from opaque or improper licensing practices and empower the state to safeguard the economic rights of artists, musicians, and other copyright holders," end quote. The government said it remains steadfast in promoting a creative economy that is fair and transparent. The full interview with Ecco can be found on SK Newsline's Facebook page and YouTube channel. Andre Huey, SKN Newsline.